5, 4, 3, 2, 1. Learned counsel appearing for the petitioner submits that petitioner is a sincere person and there is no complaint from any corner against him. Petitioner could not present himself for duty in time because on 5/5/2011 his wife gave birth to a child and both mother as well as child were not well and were admitted in the hospital, and for that purpose petitioner was busy for their treatment. The matter was duly informed by him before the authorities concerned. After recovery of mother and child, petitioner presented himself for performing duties. Learned counsel further argues that while he was posted at Godda, he fell ill and after due information to the authorities, he underwent treatment under one Dr. A.K. Gupta, medical officer, Sadar Hospital, Dumka, and he remained under treatment from 8/10/2011 to 30/4/2012. After his recovery, he reported for duties on 1/5/2012. Order of dismissal from the service is too harsh and not commensurate to the charges leveled against the petitioner. The appellate authority has also not considered facts and circumstances of the case, and as such the impugned orders passed by the respondent numbers 2 and 4 are fit to be quashed and set aside. The impugned orders is in utter violation of Rule 826 of Jharkhand Police Manual. Petitioner has not been allowed to adduce evidence nor the principles of natural justice has been followed in this case. Learned G.A. 5 appearing on behalf of the state submits that petitioner has violated the basic rule of a disciplined force. He unauthorizedly absented from the duties on several occasions and even did not bother to file reply to show cause. Such attitude of the members of a disciplined force is not acceptable, and as such no interference is warranted. Writ petition is fit to be rejected. From bare perusal of the case at hand, it appears that though petitioner has violated the basic rule of a disciplined force and absented himself without prior permission, but the punishment appears to be disproportionate to the charges leveled against him. In the case of the RC petitioner, the concerned authority alleged that he failed to maintain devotion to duty and his behavior was unbecoming of a government servant. The question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstances. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control like illness, accident, hospitalization, etc. But in such cases, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the said absence from duty is willful. However, in absence of such finding, the absence will not amount to misconduct. This court feels that when the charges are not so grave, such a harsh punishment is not warranted. Similar issue fell for consideration in the case of Krishnakant B. Parmar versus Union of India and another reported in 2013 3 SCC 178. The judgment passed in the case of M.V. Bijlani versus Union of India reported in 2006 5 SCC 88 has also been discussed. It is relevant to quote para 18 to 20 of the judgment passed in the case of Krishnakant B. Parma Supra, which reads as under: in a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In the present case, the inquiry officer, on appreciation of evidence, though held that the appellant was unauthorizedly absent from duty but failed to hold that the absence was willful, the disciplinary authority, as also the appellate authority, failed to appreciate the same and wrongly held the appellant guilty. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.